Yes, out of the 21 provisions of the Cybercrime Prevention Act of 2012 violated, out of the 21 section, I don't know where is this coming from. 21 sections. Yes, out of the 21 sections of the Cybercrime law challenged by the petitioners. Supreme Court declared three provisions. The court in Section 4 should place great weight in the protection of commercial speech. It is ruled that unconsolidated advertisement are legitimate forms of expression. It ruled that there is no basis to the claim that the presence of unsolicited commercial communication or spam tend to slow down the efficiency of computers as well as its storage, and it's considered as a nuisance to the users. Commercial speech is afforded protection in this case, further stating that people have the right to read one's email, and the denial of such constitutes violation of freedom of expression. It is noted that these messages form part of the freedom of speech and were never considered as nuisance. Some people may even be interested in that as long as the people have the right of option whether to open the mail or not. As to Section 12, the court found that it failed to provide safeguard to the right of privacy of every individual, as it authorities given to law enforcement authorities to gather electronic traffic data referred as the date, time, size, origin, etc. of a certain communication. It is declared as unconstitutional as it must be specific and definite to ensure that the rights of every individual are protected. The court ruled that the authority given under this section is without restraint, although the law states that the collection of data is limited to those associated with specified communication. It is still the law enforcement agency that would specify the target communications. It is noted that every single information, when collected and gathered, may create profiles of persons, including their political views, associations, and activities, which is protected by the right to privacy. Okay. So excited, so excited, I'm so excited for this month. Lastly, the court declares Section 19 as unconstitutional as it violates the constitutional guarantees to freedom of expression and against unreasonable searches and seizures. The section gives power to the DOJ to block access to a computer data which is found to be prima facie a violation of the cybercrime law without the need of a search warrant is guaranteed by the 1987 Constitution in Section 2, Article 3, that every person has the right to be secured against any unreasonable searches and seizures. The power granted under Section 19 of the cybercrime law clearly contradicts the constitutional rights of every individual against searches and seizures without warrant. It has also ruled that computer data constitutes speech and that curtailment of such by the DOJ through blocking any access to it restricts freedom of expression. The court and upholding the validity of several provisions ensure that the rights guaranteed by the Constitution will not be violated or restricted. So, Section 19. hmm, Searches and seizures. Ma? Wala pa pong ano ma, wala pa pong ito, tawag sa mag-message daw po sila if on the way na daw po sila. Ma? People versus Holy Barnes. Your number. 22008. Number 3, 1924. Little more the medical person in charge of La Flor de la Isabela employed Macaria Fajardo Seger, maker. She was granted a vacation leave by reason of pregnancy. People versus Kumar. Okay. Facts. Kumar, the manager and person in charge of La Flor de la Isabela, employed Macaria Pardo, cigar maker. She was granted a vacation leave by reason of pregnancy. Thereafter, a case was filed against defendant Kumar for failing to pay part of her regular wages, corresponding to 30 days before and 30 days after her delivery and confinement. In accordance with the provisions of Act Number 3071, which states that Section 13, every person, firm, or corporation owning or managing a factory, shop, or place of labor of any description shall be obliged to grant any woman employed by it as a laborer who may be pregnant 30 days vacation with pay before and another 30 days after confinement, provided that the employer shall not discharge such laborer without just cause under the penalty of being required to pay to her wages equivalent to the total of 2 months counted from the day of her discharge to said complaint. The defendant demurred, alleging that the facts therein contained did not constitute an offense. The demurrer was overruled, whereupon the defendant answered and admitted at the trial all of the allegations contained in in the complaint. The judge found the defendant guilty. From the sentence, the defendant appealed and now makes the following assignment of error. That the court erred in overruling the demurrer in convicting him of the crime charged in the information and is not declaring Section 13 of Act Number 3071 unconstitutional. Whether the provision of Section 13 of Act Number 3071 are reasonable and lawful exercise of the police power of the state. Hmm. Inherent power of the state. Okay. So William Pomar is y- 2 months. Surveyor manager Louis Pomar. Uh-huh. Mm. It's gonna be Macaria Fajardo.